8 different types of immigration scenarios in which we can't help you. Our normal techniques of a writ of mandamus lawsuit will not work in these situations. That's what's coming up. My name is Josh Goldstein, and I'm an immigration lawyer, and we help people across the country and around the world reach their immigration goals. We specialize in helping people whose cases are unreasonably delayed. They're just stuck and nothing seems to work, and we are able to step in and fix that and get them approved quickly with a writ of mandamus lawsuit. But it's not magic. There are many scenarios in which these techniques won't work. We won't take your case. We won't take your money. We can't help you, and that's what we're going to discuss today. Number 1, we cannot help you if you are delayed because of the visa bulletin. The visa bulletin is cruel and unfair and absurd, but you can't possibly get approved and you can't get a visa unless you are current for your category, your country, and your priority date according to the most recent visa bulletin. And if your case retrogresses and becomes not current during the course of a case, you're just not approvable, and it doesn't matter how much we want to help you, we're not able to do so. Number 2, aging out. What am I talking about? There are many types of immigration cases in which your 21st birthday is no cause for celebration. It means the end of your immigration case. It means you're disqualified from being approved. And sometimes we can save that with something called the Child Status Protection Act, but often we can't. What does that mean? Well, if you have one of these particular types of immigration cases in which you have to be approved before you're 21, you need to take action on that. You need to make sure that you get approved before you turn 21, because once you turn 21, you're disqualified and we can't help you. Our normal techniques of a mandamus lawsuit will not work. Number 3, we can't help you if your immigration case has a serious underlying problem. A mandamus lawsuit is a way of challenging an unfair and unreasonable processing delay, a case that's stuck. But what if the cause of the delay is actually an underlying problem, something seriously wrong? A lot of times people's cases get stuck because of what they call background checks or security checks or administrative processing or something like that. A mandamus lawsuit will work perfectly well for that. It'll clear all that up. But what if the consulate is sitting on your case because they don't actually believe that you and your spouse have a genuine, meaningful marriage relationship? If you're unable to prove that your marriage is genuine, then you're not going to be able to get approved, and it doesn't matter if we sue the consulate for delaying your case. Your case has a problem, and our techniques will not result in a successful outcome. Number 4, membership in SEPA, or the Islamic Revolutionary Guard Corps, IRGC. This is a particular branch of the Iranian military. And if you serve in this particular group, you are ineligible from getting a visa. When someone contacts us and they're male and they're from Iran, we ask them, did you serve in SEPA? If they say yes, then we decline to represent them. It's not because we don't want to help them. It's not because we don't care about them or we don't like them or anything like that. It's just that we don't have a technique for getting them approved. And if someone hires us and they're male and they're from Iran, we ask them again after they hire us, are you sure you didn't serve in SEPA? We check again and again and again throughout our process, because we don't want someone to hire us and pay us money and then have them have a disappointing outcome. A lot of times people who have this issue, they get mad and they're like, well, yeah, I served in SEPA, but you don't understand. It wasn't my choice. They forced me to do it. And I worked in the library for 1 week and I never did it. I get it. I understand all that and I have sympathy. But nevertheless, SEPA membership, IRGC membership is something where we cannot help you. Number 5, DV lottery cases that have expired or that are past the September 30th deadline. The United States of America gives out green cards for free through a lottery system. Everyone who's eligible who wants a green card should apply. I'm a big fan of this program. One of the quirks is that you have to get approved by September 30th. After September 30th, your case is over. You cannot possibly be approved. So sometimes we'll get contacted by people and they'll say, yeah, my case is in administrative processing. I have a DV lottery case and it happened 3 years ago and now I want you to step in and fight this. This is so unfair. They sat on my case. I agree that it's unfair. I agree that you deserve the visa that you should have gotten. But nevertheless, a mandamus lawsuit won't help you because you're no longer eligible to be approved after that September 30th date has passed. Number 6, if you yourself are the cause of the delay. We recently had an immigration case. We were preparing a mandamus lawsuit and we looked into the facts a little more and we found out that the case was delayed. But the reason for the delay is that the National Visa Center had requested certain documents and the client had not provided the requested documents. So the case had grind to a halt and was stuck. And we went back to the client. We said, wait a minute, you never provided these documents. And they said, yeah, but it's really, really hard to find those documents. How are we going to find the documents? I understand that it's hard to track down all sorts of different documents, but if the reason that the case is not progressing is that they've requested documents that you haven't provided, a lawsuit to challenge the processing delay is not going to fix that. Instead, we tried to help the client find the documents because we're an immigration law firm. This is what we do. We handle this sorts of things all the time. We have expertise and know-how and experience and insights into how to track down different documents. It's not easy. There's a lot of legwork involved, but this is what we do. But nevertheless, a lawsuit attacking the delay as unreasonable is not going to help you if the reason for the delay is that you didn't give them the documents that they asked for. Number 7, we cannot help you if you got an adverse decision from an embassy or a consulate. If you applied for a visa and the consulate denied your application for a visa and you are unhappy with that decision, you think that the decision was unfair, was unreasonable, was absurd, was ridiculous, was a travesty of justice, if the consulate made an egregious error, if they're wrong, we can't help you because of a few reasons. First of all, a mandamus lawsuit is not an appeal. An appeal is when you challenge a decision that you don't like. You fight it. But there is something called the doctrine of consular non-reviewability. That's a mouthful. But what it means is that the consulate or embassy, when they're reviewing a visa application, they can make whatever damn decision they want. It doesn't matter how unfair, unreasonable, how wrong, how bigoted, how ridiculous and absurd it is, and you're stuck with it. You can't appeal it. You can't change it. There's nothing you can do. If this sounds unfair, I agree with you. It is unfair. But guess what? The Supreme Court recently reviewed the doctrine of consular non-reviewability, and the Supreme Court said, this is great, we like it, we're upholding this. I disagree with that decision. If I had the power to do so, I would eliminate the doctrine of consular non-reviewability, but nevertheless, it's the law of the land, we're stuck with it, and if you get a bad decision from the consulate, then what you really need to do is work with a team of expert immigration lawyers like us, and we can help you come up with a new and different strategy, hopefully to help you reach your immigration goals. Number 8, we can't help you if the delay is not unreasonable. A mandamus lawsuit is all about attacking a processing delay because the delay is unreasonable. But what if the delay is not unreasonable? What if it's just been pending for a few months? You can't file for a green card for your wife and then sue the government a month later. That wouldn't be fair. Now, when I tell people that the delay hasn't been long enough and they need to wait a little longer, they often think that I'm being unsympathetic or lacking empathy, and I'm not. All I'm trying to do is make sure that people who hire us have a good decision and that your case has merit. And people often say, well, how long is too long? How are we going to know once we've reached the point that we can file a lawsuit? The answer is, it depends. We have complex criteria that we use to evaluate cases because there's many different types of immigration cases. And we want to know when you filed the case and whether there was an interview and what the case steps were. We want to know about the hardship. How is the delay impacting you? We want to know a lot about your particular scenario before we can tell you, yes, we can help you, or no, we can't. if you're wondering whether your particular delayed immigration case would be suitable for a mandamus lawsuit, I have good news for you, because we offer a free strategy session to anyone who qualifies. All you have to do is fill out a questionnaire, answer a few simple questions that you'll find in the link below in the description. And if you qualify, you'll have a free case evaluation with our team. We can review the merits of your case. And if we can help you, we absolutely will. We will do everything we can to help you reach your immigration goal.